Good afternoon and welcome to Little Steps Live. Today in Hong Kong, my name is Nikki and thank you for joining us. Getting a divorce is a big step and something you may have been considering for a while. But before you initiate divorce proceedings, there are many factors you'll need to take into account, such as custody, financial maintenance, dividing of assets, and more. To help negotiate these matters, you'll need a lawyer or a mediator who can help you resolve the most contentious aspects of your separation. While there may be some tough decisions to make along the way, you can positively move forward from this difficult time with the right advice. If you want to know more about divorce, child custody, and mediation, then stay tuned as we are joined by a panel of lawyers who will answer all our questions. But before we get started with our topic, a few friendly reminders from Little Steps. We are live twice a month. If you want to be reminded of our live sessions directly to your phone, make sure to check our Facebook events calendar and simply click the topics that you're interested in. Please also sign up for our weekly newsletters across our cities in Asia, from Hong Kong to Singapore to KL and beyond. The link for this is in the description below. We are live, so feel free to ask us questions, add comments, and interact with us here right now. If not, don't worry, we will get back to you after the live session has ended. Now to welcome our guest. I would like to introduce you to our guest today, Elsie Liu, who heads the family group at Haldanes, and her team, Elaine, Willard, Anita, and Patricia. With a wealth of experience in matrimonial law between them, they're here to tell you how to best navigate divorce, custody, and mediation. Now, as usual, we will be splitting today's discussion into four main topics. The first, all about divorce. Number two, children's matters. The third, financial matters. And four, using mediation. Now, let's get started with our topic. I want to welcome everybody at Haldanes. Welcome. Hello.
Hello, thank you very
Hi.
much.
Hello, everyone. Hello. It's great to have you all here. Now let's just get into it. Let's get started. So the first one is all about divorce. So my number one question is, do I need a lawyer to get a divorce? Elsie, would you like to answer that, please?
Sure. Strictly speaking, you don't need a lawyer to get a divorce. However, given that there are a lot of documents, you need a court proceedings involved, I would strongly recommend that all parties seek advice from a lawyer to ensure that there is no problem later on, because we do come across a lot of cases. They think that it's rather simple, but then subsequently they find out that certain documents was not done properly, and therefore we do have to do a lot of rectification subsequently. So I would recommend that people do seek legal advice for getting a divorce.
I see. Great. Thank you. Thank you so much. And what are the possible grounds for divorce? Willard, can you answer me that, please?
Yeah, sure. There's actually only one ground of divorce, which is marriage has broken down irretrievably. But there are five facts to support this ground. So we commonly refer to these five facts as the grounds. Starting from the top, it would be adultery, separation, either 1 year of separation with the consent of the other party, or 2 years of separation. The other common ground would be unreasonable behavior, and a more obscure ground would be desertion, which is rarely used.
And why is that rarely used, desertion? Just for the people who need to know.
It's just something that doesn't come up very commonly these days.
And what would you say is the more common one? The unreasonable grounds?
The most common grounds that we see would be separation, either 1 year with consent in cases where the parties can cooperate, 2 years of separation, or unreasonable behavior. Because under the ground of unreasonable behavior, you do not need to undergo a period of separation first.
I see. Thank you so much. Now, and how do I start divorce proceedings and how long does it usually take?
Right. So the most common way of starting a divorce proceeding would be for one spouse or the other to issue a divorce petition. They can also do a joint application, but this can get a bit complicated because there would be a duplication of documents and the two parties would have to cooperate very closely in the process. As to how long it would take, in the most ideal situation where the couple can agree the ground of the divorce and all the different issues, such as the children's issues and financial issues, if they can agree all of the documentation, after filing all of the documents, it would take about 6 months to get the decree of divorce nisi, which is the temporary decree of divorce. After this, the parties can apply for the decree absolute in 6 weeks. So this is the final decree of divorce. That will take about 4 weeks after the application. So if everything goes smoothly, the quickest it can happen is about 8 months from the time of filing the divorce to the granting of the decree absolute.
I see. So the shortest time will be around 8 months, but I can imagine that it can also take a longer time depending on the parties and if they wish to agree with each other or not.
Yeah, it really depends on what is in dispute. I mean, if it becomes a contentious divorce case where a lot of things are disputed, then it can stretch on maybe 2 years or more.
I see. Thank you. Thank you so much. Now, for
You're
those who
welcome.
have just joined us today, we are here today with the Haldanes solicitors, and our topic is what you need to know about divorce. We have just covered topic 1, all about divorce. Any questions that still need to be asked or want to be asked, please comment them below on our Facebook page. We will get back to you. All the answers will be answered. So please email us or contact us right here, right now, and we will get back to you. Now we're moving on to topic 2, which is children's matters. And this is quite an important topic, obviously, during a divorce if there are children involved. So the first question is, how can we minimize the impact the divorce process has on children? Now, Patricia, can you please answer me that?
Yeah, sure. The best way to minimize the impact, I would say, is both parents should actually try to reach a settlement over the children's care arrangements or all the other matters arise from the divorce as soon as possible. And it will be best to actually do it outside court. Because you can imagine during the divorce proceedings or during the couple's separation, the children are actually caught in the middle and they are very stressful. So the sooner they can actually reach a settlement, the least impact would have on the children. However, in the unfortunate event that they are not able to reach any settlement, then they will have to go to court. And during the proceedings, I would advise the clients normally not to try to drag the children into the proceedings and to let them know all the details about the court proceedings, because this will actually affect them a lot and maybe actually cause psychological harm to the children. I would also say that even though there's so much conflict between the parents, they shouldn't badmouth each other in front of the children, or they should avoid fighting each other in front of the children, because this will also bring a very negative impact on the children. And not to ask the children to take side with one parent. This will also bring a very long-term, long-lasting effect between one parent and the children.
Understandable. So, of course, what you're saying is try to be as amicable towards one another when the children are in front, and trying to get to a decision with the children rather than against one another and trying to put the children against one another as well. Understandable, of course. Now, what is the difference between joint custody and sole custody, and how are they typically decided, Patricia?
Well, the term custody means the right to make the important decisions in the child's life, including schooling, medical decisions, and religious belief. So sole custody, meaning that the parent who has sole custody will ultimately have the decision-making power on one particular important matter, such as schooling. However, it does not mean that the non-custodial parent will not have any right to consult it. So if the non-custodian parent does not agree or strongly think that a decision made by the custodian parent is not in the best interest of the children, the non-custodian parent can always go to the court and make an application and ask the court to make a decision on that particular important matter. And for joint custody, it means both parents must consult with each other on the important matter, and they will have to agree with each other on this matter. If they are not able to reach any agreement, then they will have to go to court for decision.
And a side question. Let's say a parent starts off with joint custody and they wish to change to sole custody. Can this be altered after as well? Let's say a decision has first been made to give one parent joint custody, or they've both given or one has been given sole. Can this be altered after as well?
Yes, the court has jurisdiction over the issue of custody as long as the children are under 18. So if the children are still under 18, then these issues can always be varied or altered. So if you have joint custody now and you think that joint custody order is not good enough in this case, because there might be a serious lack of trust and cannot communicate with each other all the time, that may actually put the children in a more vulnerable situation, then the parent can go to court and try to ask for sole custody and vice versa.
Okay, great. Thank you so much. Please continue.
So in determining how joint custody and sole custody are determined, the court always look at the best interest and the welfare of the children. So this is the first and paramount consideration. In most cases in Hong Kong, joint custody order is most appropriate because it aligns with the principle that it will give both parents equal role to participate in the upbringing and the important decision making of the matter over the children.
Yes, of course. Thank you. Now, if I'd like my child to continue to live with me after divorce, what factors would the court consider determining this matter? Elaine, I'm directing this question to you, please. Thank you.
Yeah, as Patricia has just said, the court's paramount consideration is what is best for the children, so their best interest. And if there are disputes over who the child should live with, that is what we call the care and control order, then the court will call for what we call the social investigation report. That means the social work officer will be involved. He or she will be like the court's eyes and ears. He or she will interview the child, the parents, of course, and interview the child. And the child may let the social work officer know what her or his wishes are, and so that's how the report will cover, and the court will consider what is said in the report, and will see whether, say, for example, who is the primary carer during the marriage, whether how the order can minimize the disruption to the children, so these are all the factors the court will look into. There would be, say, for example, sole care and control order, or whether there should be a joint care and control order, because the role both parents are more involved in the child's upbringing nowadays. So the court may also consider whether shared or joint care and control would be a suitable or appropriate order for the child.
Okay, wonderful to know. Because from my understanding, it is common that the mother will get sole custody, but I can see that in Hong Kong, often joint custody is considered, which is a good thing. Absolutely. Thank you. So for those who are just joining us today, we are joined here today with a panel of Haldanes solicitors, and we are discussing the topic, what you need to know about divorce and mediation. We are now going on to our third topic. We have just discussed children's matters. Again, if you have any questions coming in, please comment down below during our live session and ask any questions. We will get back to you. Now we're going into topic 3, which is financial matters. And my first question is, what are considered family assets and how will they be divided? Elsie, Anita, I think this is one for you. Yes.
Yes, thank you, Nikki. I think that this is a quite common question from our clients. What are to be considered as the family assets? In fact, many people may think that only those properties or assets held under the joint names of the parties will be regarded as the family assets for the purpose of the divorce. But in fact, it is not. The court will assume that all the assets, no matter it is under the joint names of the parties or held under the sole name of each party, the court will first consider they are family assets and will apply them to meet the financial needs of the parties and the children at the time of the divorce. Unless these assets are more than enough to meet the financial needs of both couple and also the children, then the court will then consider whether they, the nature or the source of these kind of assets, whether they can be excluded as the family assets for the purpose of division. So that is the case, the court will consider whether these assets are acquired by either party before the marriage, or it is some gift or inheritance received by one party during the marriage, which has nothing to do with the marriage, or we can say that it is not the contribution from the other party for the marriage. In that case, the court may consider whether these kind of assets can be excluded and not be treated as the family assets for the purpose of division. And if the case is that if the assets are more than sufficient to meet the financial needs of the parties and also the children, the court may first presume maybe there is an equal division of these assets between the parties. But of course, the court will also consider whether there are any factors which can depart this equal share. For example, the length of the marriage, the standard of living during the marriage, or whether there is one party has special mental or physical disability, which require more financial needs in deciding whether each party shall get 50% of the share or even more or less from the division. There is something interesting from our clients. Sometimes because the standard of living will be taken into account in the division. Some of my clients will say that if I'm too generous to my spouse during the marriage, will I have to pay more at the time of the divorce? There is some case that maybe that is the case because the financial standard of living will be taken into account. And
Awesome.
and that is also one interesting point. If you try to put some assets in a third party, for example, a friend or a family member to hold that assets on your behalf, then in that case, your spouse may be able to ask the court to take into account that part of assets to be the family assets for the division. And of course, sometimes if you hold an asset on your behalf, on the behalf of your parents or a friend, then this family member or the friend which you just hold the assets on trust for him or her can also try to join in the divorce proceedings and call back their assets. But this is something more complex for the divorce case.
Awesome. That was a really great answer. Now, my next question is, what is maintenance and who would be entitled to receiving it?
In fact, maintenance is a generic term. It is include both the spousal maintenance and the children maintenance. The maintenance is that for the spousal maintenance, the spouse may be entitled to the capital division of the family assets accrued during the marriage. So in that case, the court can consider to grant some sales or the transfer of assets order, or even a substantial amount of the lump sum payment. And in that case, they may be able to achieve, which we always call the clean break settlement. That means you just pay off one lump sum to the spouse, and then you may not need to pay for the ongoing maintenance for that spouse. And of course, for the spousal maintenance, if there is insufficient assets to incur a sufficient lump sum to provide for her future needs, then in that case, the court may still consider to give some monthly maintenance order. And the term of such spousal maintenance can be a fixed term order or a lifelong maintenance, which during the joint lives of the payer and the payee, and also upon the remarriage of the payee, then the monthly maintenance for the former spouse can be stopped. But for the children maintenance, it will be mainly a monthly maintenance sum to the children until that children reach the age of 18 or ceases full-time education, which time is later, and usually for Hong Kong, it will be up to a first university degree.
Okay, great. Now, just a quick question regarding maintenance. Let's say a spouse, whoever is paying the maintenance, gets a new job and is paid more or less. Will that change the maintenance as well? Can he or she then go to court and say, I'm either now paying too much or paying too little because my job has changed?
This is also a quite common issue after the divorce, because under the Hong Kong law, whenever there is a change of the financial circumstances of the payer or payee, or even the financial list of the children, once there is a substantial change, either party, no matter you are the one who pay the maintenance or receive the maintenance, you are entitled to make an application to the court to vary the amount of that maintenance or the term of that maintenance. If sometimes you lose a job and temporarily can't meet the former maintenance order, you are still entitled to apply to the court, maybe have some certain period of suspension of the payment of that maintenance or reduce in the amount.
Okay, great. Thank you. Now, and what if my ex-partner has a new partner and may have a child with this person? How will the court deal with the finances in this case?
There are some cases law, the judge has indicated that when you marry a husband or wife, you will have to take all encumbrance of that person for the marriage. That means you know that he or she has some former financial obligations towards the first family. You are also taking up subject to those obligations. But of course, in practice, the court will does not want to make either party to have financial hardship, particularly for the children's financial list. So sometimes the court will take into account that payer's legal and moral obligations to maintain his first family and the second one, and will still try to make a balance and meet the financial list between the two families.
Fantastic. Thank you, Anita. Thank you for answering those questions beautifully. Now, we're already moving on to our last topic, which is using mediation. If you've just joined us, I'm here with the Haldanes solicitors, and we are discussing what you need to know about divorce and mediation. And we have discussed various topics beforehand. You can look back, of course, on YouTube or on Facebook Live, the full video. So now we're going on to our last and final topic, which is using mediation. It might be quite unclear for most of our audience, so let's go straight into it. What is mediation? Elsie, can you help us with this question, please?
Sure. Thank you, Nikki. Well, actually, mediation is a voluntary process. Well, you may find that when the parties have a breakdown of the marriage, it is quite natural that they may not be able to communicate effectively. Therefore, if the parties try to talk about the terms of settlement, they will not be able to reach any agreement. And sometimes they don't want to involve lawyers because sometimes lawyer will make things more complicated. Sometimes, I'm just saying sometimes only. Therefore, I think in that situation, it would be helpful to have a neutral party who will help and facilitate the parties to negotiate between themselves. And the role of a mediator is to help the parties to generate different options and see if they can reach an agreement outside court process.
I see. And is there a big difference in financial payment between a mediator and a lawyer as well?
I beg your pardon?
Was there a big difference between payment of a mediator and a lawyer?
Oh, yes. Yes. Well, actually, it depends on who you look for in terms of being a mediator, because they have different backgrounds. It could be social welfare officer, or it could be a lawyer. I myself is an accredited family mediator, so I have known about the family law. But in terms of the cost, if you are engaged in a mediation setting, normally both parties shall share the cost equally. Whereas if you go to court, you will have your own lawyer and the other parties will have their own lawyers. So in terms of cost, there is a huge difference.
Fantastic. So, and this brings me on to the next question. How does mediation then help with divorce? We've already discussed costs, and how does it else help with divorce?
Well, I think that as Patricia and Elaine has correctly pointed out, it would be best not to involve the children. And I think that children is one of the topics that would require cooperation, because the kids, despite the parents, as I've always said to my client, despite two of you cannot be husband and wife, you will always be the parents of your children. Therefore, I think it is important to preserve the relationship in order to achieve co-parenting. Therefore, having the children arrangement being agreed through mediation, it will be less contentious. And also, think it this way: you have a judge to make decision for your child who does not know well of your child. I think the alternative resolution is to have the parties to sit together who knows their children and then plan for them with agreement between the two of them.
I see.
The other benefit is that because mediation is without prejudice and confidential, so basically you are free to express your view, and all this information obtained through mediation is confidential. So neither the party can share those information in court. Therefore, you don't have to be worried that what you said is going to prejudice you in court.
I see. That's great to know. So, can you explain a little bit more how the mediation process differs from the court proceedings exactly?
Right. Well, actually, even though the parties involved in mediation process, it doesn't mean that you can do away with not having a court proceedings, because under the Hong Kong law, you need to have the court to pronounce the divorce, and the court will make order in relation to children matters and also financial matters. However, the mediation and the court proceedings can go parallel, i.e. you can't have mediation on one side and then you can do mediation, and hopefully if you reach an agreement, instead of involving into court hearing, filing of documents, questionnaire or social welfare report, you can have a mediation agreement. Once there's an agreement, your lawyer can then convert it into a court document called consent summons, and the court will then make an order of the court. You don't have to walk through every single step that the contested divorce will have to go through. So in terms of timing, in terms of cost, in terms of animosity, definitely mediation, I think, is a much better route than going to court.
Fantastic. Thank you. We've actually got some questions, some anonymous questions coming in from our audience. And one of them is also regarding mediation. And it's asked, how can I encourage my ex to use a mediator? Can you answer this, Elsie?
Sure. I think that the benefit of doing mediation is that, as I've said before, you get to make a decision between yourselves rather than having a third party. I mean, I've mentioned about the benefit of cost. I have mentioned about you don't have to go through the entire court process in terms of timing. But then I think one important thing, in particular with people with children, because I've always said to them that one thing is that the court is not going to ask, "Hi, Daddy, do you like this proposal?" or "Hi, Mommy, do you like this proposal?" The court, after hearing each party's cases, the court is going to make a decision. And the decision may not be the one which the mother is fully happy or the father is fully happy. So I think that mediation is a forum that gives the parties to at least reach an agreement or make an arrangement that they can live with. At least they know what they are getting themselves into, rather than leaving a third party, a judge, to make decision for them.
Of course. And can it happen sometimes that couples start off with mediation and then will still need to go through court, where the mediator simply cannot make the parties agree with one another and it still goes to court? Is this something that happens often, or does it often stay just when a mediator is chosen, it stays in mediation?
Well, of course, I mean, if my clients come to me and instructed me as a mediator, then of course I would do my best to try to reach an agreement for them.
Yeah.
Unfortunately, if they can't, they will have to go back to the court process. So it does happen, but for the cases that I mostly handle, keep my finger crossed. Normally, they will be able to reach an agreement. Yes.
Fantastic. Thank you. Now we have another question come in from the audience, and it asks, what can I do if my child or children are really struggling with divorce? Who can I direct this to? Patricia, perhaps?
Yes, sure. Okay, so for that, because as we mentioned before, children are always under lots of pressure during the separation and the divorce. So if they're really struggling, actually, which in my experience it happens from time to time, we can actually suggest the children to attend individual therapy with a child psychologist, or sometimes they can even go through the family therapy, like the whole family, 4 members, 3 members, sit together with a family therapist to talk through about the difficulties and try to resolve the conflict. So there are different types of therapy that the family or the children can attend. And sometimes, because you can also foresee that, because divorce is a very tough process for everyone else who is going through that. So the parents may actually also need therapy from the counselor or psychologist, so that they will be able to actually cope with their own emotions and not to present these emotions and affect their children. So there are different ways to try to minimize the impact that the process has on the children. And sometimes parenting coordinator can also be appointed, so that to try to have this parenting coordinator to resolve the conflict, the day-to-day conflict between the parents over the children's matter. Because when we go to court, we can only go to court maybe once every few months, because the court is very busy. But having a parenting coordinator, we will have her or him being present from time to time and help the parents to communicate, and also educate the parents as to how to co-parent the children.
Fantastic. Thank you so much. And thanks to the audience for our questions. And we've come to the end of our interview. I want to thank everybody at Haldanes for this wonderful interview and answering all our questions. Do you have anything to add before I finalize our session?
Well, thanks very much, Nikki, for having us.
Thank you. This has been so enlightening. It's been very, these are really good. I think a lot of our audience has these kind of questions and maybe too afraid to ask them. So it's wonderful to have this just on video, and people can look at these questions in their own time and comfort. Now, if you have any more questions about divorce and mediation, please visit Haldanes' website at www.haldanes.com. Of course, the link will be in the description below. Again, I want to thank everyone for joining us, and thanks so much for the team at Haldanes for helping us understand how to best handle divorce, child custody, and how mediation can help. If you'd like to know more about us or see similar videos, don't forget to subscribe to our YouTube channels, follow us on social media, and to subscribe to our newsletters. Thank you very much, everyone. Have a lovely day, and thank you. Goodbye.
Thank you.
Thank you. Thank you. Bye-bye.
Bye-bye.